Assalamualaikum warahmatullahi ta'ala wa barakatuh. Greetings of peace to everyone. Good day. This video will present 3 different civil cases within the original jurisdiction of the Municipal Trial Court as part of the requirements for Practice Court 1, subject of Mindanao State University College of Law, General Santos City. Submitted to Attorney Habari L. Balt, Assistant Dean. Submitted by Mr. Isaias L. Goles Jr., Ms. Ellen May C. Riuyan, and Ms. Charmaine Joyce S. Maningo. Case number 1, GR number 183035, January 9, 2013, Optima Realty Corporation versus Hertz Philippines Exclusive Cars Incorporated. Researcher, Ellen May Riuyan. Penned by Justice Sereno.
Hello, good morning, attorney.
Hi, Mom. Good morning. What can I do for you?
Attorney, I would just like to seek your legal advice because I am planning to file a case.
Okay. But first, I need you to give me your name, your address, your age, and of course, your background.
Yes, attorney, I'm Ellen May Riuyan. I'm 33 years old attorney from Makati City. I'm the CEO of the Optima Corporation, and we are engaged in the leasing business, and we're renting out commercial spaces to our tenants.
Okay. So, who would you want to sue, and why would you want to file a case?
I would like to sue our tenant attorney, Hertz, the Exclusive Cars Incorporated. We have entered into a contract of lease with them, but they failed to pay the rental for 7 months and of course the utility bills for 4 months.
Okay. When did you enter such contract of lease, and what are the terms of the contract?
It was entered in December 2002, attorney, and it was a 3-year contract from March 2003 to February 2006. So we amended our lease agreement to 2 years and 5 months from October 2003 to February 2006. So by that, attorney, sometime in 2005, we have renovated the area, and because of that, they allege that they have lost 50% of their sales. So they seek 50% discount from us, which we have also given to them. However, they still failed to pay the rental bills from December 2005 to February 2006, which is the 4 months utility bills, and the August 2005 to February 2006. That's the 7 months rental payment, attorney.
Okay, noted. Is there any written notice of demand given to them about this?
Yes, attorney. We have already give them or wrote them a letter of demand to remind them that the contract would not be renewed if they would not negotiate for the extension of the renewal of the contract, and they are given 90 days prior to the expiration of the term.
So, what was their response?
There was no response, attorney, and there was no letter coming from them to seek negotiation from us for the extension of the renewal of their contract of lease.
So, what do you want to happen now?
I want them to surrender and vacate the premises, attorney, and in view of the expiration of the contract of lease and demand for the payment of the rental and utility bills.
Okay. I would know if there is any pending case that you have filed against them.
No, attorney. There was no pending case against them.
Okay, no pending case. How about, do you have any evidences or witnesses which you can provide for this case?
Yes, attorney. I have here our contract of lease,
okay,
and written demand letter prior to the expiration of the contract to remind them of the condition before we will renew their
okay. We can write a written demand letter for them to surrender and vacate the premises, in view of now that the contract has expired. And of course, we can demand payment for the back rentals as well as the failure to pay the utility bills, as you said, amounted to 4 months.
Okay, attorney. If they still don't comply with that, attorney, what case can I file against them?
Well, if they will not comply with our demand, we can file a case of unlawful detainer against them.
What is unlawful detainer, attorney?
Well, if I can tell you what is about unlawful detainer, it is an ejectment case actually. It is the recovery of possession of real property from the one who legally withholds possession of it after the expiration of the contract. It was at first the possession was lawful, however it turned unlawful after the expiration of the right to possess. So in unlawful detainer are filed before the Metropolitan Trial Court, or the MTC. So in our case, since the property is in Makati, we can file the unlawful detainer suit against your former lessor with the Municipal Trial Court of Makati.
Yes, attorney. Our contract of lease has already been expired and terminated, and I would like to recover the premises.
Okay. As long as, of course, if you are willing to pay the docket fee, of course, and the acceptance fee, and you have evidences that you can establish and proceed with the suit, and you are willing, and this is important, you are willing to participate with the suit processes.
Yes, attorney. I am willing to go through the process, and I am willing to pay for the any cost of this.
Okay, very good. All right then. Just a short reminder. I just would like to inform you that the Integrated Bar of the Philippines, this is the group of lawyers in the Philippines, has an approved tariff in accepting cases. This will serve as my acceptance fee. Are you willing to pay for that?
Yes, attorney.
Okay, everything has been recorded. We'll proceed with the written demand letter.
Okay, thank you, attorney.
No worries, my pleasure. Have a great day.
Yes, thank you, attorney.
Thank you.
The METC rendered a decision ruling that Petitioner Optima had established its right to evict Hertz from the subject premises due to non-payment of rentals and the expiration of the period of lease. The RTC affirmed it by dismissing the appeal. The CA ruled that due to the improper service of summons, the METC failed to acquire jurisdiction over the person of the respondent Hertz. The appellate court thereafter reversed the RTC decision and remanded the case to the METC to ensure the proper service of summons. Issue of the case: whether or not the METC properly acquired jurisdiction over the person of the respondent Hertz. The Supreme Court ruled, yes, in civil cases, jurisdiction over the person of the defendant may be acquired either by service of summons or by the defendant's voluntary appearance in the court and submission to its authority. Preliminary jurisdiction over the defendant in a civil case is acquired either by the coercive power of legal processes exerted over his person or his voluntary appearance in court. As a general proposition, one who seeks an affirmative relief is deemed to have submitted to the jurisdiction of the court. The filing of the motions to admit answers, etc., is considered voluntary submission to the court's jurisdiction. In this case, the records show that in spite of the defective service of summons, the defendant opted to file the instant answer with counterclaim with leave of court. Furthermore, the answer with counterclaim filed by Hertz never raised the defense of improper service of summons, measured against the standards in Philippine Commercial International Bank, these actions led to no other conclusion than that Hertz voluntarily appeared before the court by virtue of the voluntary appearance of respondent Hertz before the METC. The trial court acquired jurisdiction over the respondents. Wherefore, in view of the foregoing, the instant petition for review is granted. The assailed decision and resolution of the Court of Appeals are hereby reversed and set aside. Thank you. Case number 2, GR number 204361, July 4, 2018. Cecilia T. Havelosa, represented by her attorney-in-fact, Maria Diana J. Jimenez, petitioner, versus Ezekiel Tapus, Mario Madriaga, Danny M. Tapus, Juanita Tapus, and Aurora Madriaga, respondents. Researcher, Charmaine Joyce S. Maningo. Hello, attorney.
Hi, good morning.
Good morning, attorney. Thank you so much.
Yes, what can I do for you?
Hello, attorney. I'd like to file a case. I'd like to seek your legal advice.
Okay, first, may I know your full name, your address, age, and your
I
background?
am Cecilia Havelosa, attorney. I am 35 years old. I am from General Santos City, attorney. Attorney, my problem is that I have a land property in Boracay. It is more or less 10,000 square meters.
Okay.
It is donated to me by my grandfather, Mr. Cirilo Tidol.
Okay.
Right now, attorney, I don't have the possession of that property because somebody is taking the ownership of that property, and I'd like to get back that property, attorney.
Okay, do you have the transfer certificate of the title?
Yes, attorney, I have here the transfer of certificate of title.
Okay, let me see. May I see this? Okay, so who would you want to sue, and why you would want to file?
Yes, attorney, I'd like to sue Mr. Ezekiel Tapus and his siblings, attorney, because I found out from my daughter that they wanted to sell the property, attorney. They wanted to sell it, and I was alarmed because the title is mine. So they should not sell it because they don't own that property, attorney.
So was there any written notice of demand?
Yes, actually, attorney, we went to barangay in Boracay, attorney. We went there, and then Lupong Tagapamayapa wanted us to settle. However, there was no amicable settlement then.
So was there any reply from them?
No, attorney, there was no reply from the family of Tapos, attorney. They're really hesitant to surrender the said property to us.
Okay, so what you would want them to do? You want them to surrender and vacate the property?
Yes, attorney, I want them to surrender the property and vacate it. However, attorney, the family of Tapos said that they've been there since time immemorial. Actually, attorney, the grandfather of the Tapos family is the caretaker only of our property. And they've been there for more than 70 years already. So they said they have the right to own that land. However, they don't have any documents.
Okay.
Also, attorney, they wanted to aver their rights that they are indigenous and they have the right of that property.
Okay. Can you provide witnesses for this case?
Yes, attorney, I have witnesses, attorney, that I can provide.
Okay. Was there any pending case against them?
No, attorney, there was no pending case yet.
Alright. We will then write a written demand letter for them to surrender and vacate the property.
Okay, attorney. What will happen if they will still not vacate the property?
Okay. If they will not comply with our demand, we can file in unlawful detainer case against them.
Unlawful detainer case?
Yes.
What is that, attorney?
Okay. Unlawful detainer case is remedy for the recovery of the possession of the real property from one who is illegally withholds of that possession. So it is when that possession was originally lawful from the start, but eventually it turned out to be unlawful after or upon the expiration of the right to possess. As we have told me, as you have shared, that the family of Tapus occupied the subject property upon the tolerance of your grandfather. So consequently, they must vacate as soon as the said permission was being withdrawn.
Okay, attorney, that's what I wanted them to do, attorney.
Okay, as long as you're willing to pay the docket fee and the acceptance fee?
Yes, I am willing, attorney.
Okay, so that because we have already these evidences, we can establish and proceed with the suit. And are you willing to participate with the suit processes?
Of course, attorney.
Okay.
I will do anything.
Alright, then everything has been recorded and we will proceed with the written demand letter.
Okay, attorney, thank you very much for your time, attorney.
Okay, no worries, my pleasure. Alright, day ahead.
The Municipal Trial Court awarded the subject property in favor of the petitioner and consequently ordered the respondents to vacate and pay the petitioner a monthly rental of 500 pesos. To properly determine the issue of possession, the MCTC first provisionally delved into the issue of ownership. In this regard, the MCTC held that the petitioner, being the registered owner of the subject property, is entitled to its possession. The Regional Trial Court rendered a decision affirming the ruling of the MCTC. The CA rendered the assailed decision reversing the decisions of the MCTC and the RTC. The CA rendered that although the MCTC has jurisdiction over the unlawful detainer case, the trial court, however, erred in upholding the petitioner's right to possess the subject property. The CA pointed out that the petitioner failed to prove the fact that the respondents indeed occupied the subject property through her permission and tolerance. It stressed that to make out a case for unlawful detainer, the petitioner must concomitantly prove that respondent's prior lawful possession has become unlawful due to the expiration of the right to possess the property. The petitioner failed to show that the respondents occupied the subject property pursuant to her tolerance and that such permission was present from the very start of their occupation. Absent of the fact of tolerance, the remedy of unlawful detainer would be inappropriate. At any rate, the CA did not commit any error. Under the law of the rules of court, an owner is given an assorted of legal remedies to recover possession of real property from the illegal occupant, the choice of which action to pursue rests on the owner. Should he elect to file a summary action for unlawful detainer, he must prove all the essential jurisdictional facts for such action to prosper, the most important of which is the fact that the respondent's entry into the land was lawful and based on the former's permission or tolerance. Absence of this essential jurisdictional fact, the action of unlawful detainer must be dismissed. The Supreme Court decided to dismiss the case. Thank you. Case number 3, GR number 197022, January 15, 2020. Philippine-Japan Active Carbon Corporation, petitioner versus Habib Borgaili, respondent. Researcher, Isaias L. Gores, Jr.
Assalamualaikum, attorney.
Waalaikumsalam. Panayos ka?
Yes, attorney. Attorney, I would like to seek your advice regarding the summons I received from my former lessor.
Okay, before that, may I know your name?
Yes, attorney. I am Habib Borgaile, and that I am from Davao City, and my concerned apartments, which is the subject of this case, are located in Davao City.
Oh, so what is the issue about your lessor?
Yes, attorney. My lessor is the Philippine-Japan Active Carbon Corporation.
It's a big company.
Yes, attorney. It's a corporation which leased two apartment units from me, and that if I may, we signed a contract of lease which contains a provision which requires the lessor to pay a security deposit for the two units, which shall serve as a guarantee that upon termination or expiration of the lease, that I would recover the said apartment units in good and tenable condition. And that, of course, with the exception of the wear and tear.
Do you have a copy of the contract of the lease?
Yes, attorney. I have here a copy of the contract which I will give to you later.
Yeah, you give it to my secretary.
Yes, yes, attorney. And
so what happened next?
yes, attorney. What happened next was that after the expiration of the lease, I discovered that the lease apartments, there were two units, were destroyed and had become inhabitable.
Oh no.
And as such, I had to make repairs to the damage, and that the repairs costed me 79,534 pesos. I furnished my former lessor receipts of the expenses, which included the materials and the labor for the repair, but that I also told them that I will withhold returning to them the 90,000 pesos because they paid me 90,000 pesos, 45,000 each for the two apartment units as a security deposit, and that I told them that I will not return the 90,000 pesos if they will not reimburse me with the repairs, the 79,000 plus repairs that I had incurred.
Yeah, that's the right thing to do. So what did the lessor want you to do now?
Yes, attorney, my former lessor, upon learning that I will not return the 90,000 deposit pending while I'm not reimbursed, filed actually an action with the MTCC of Davao City to compel me to return to them the security deposit without reimbursement, attorney, of the expenses.
That's too much of them.
Yes, attorney.
So,
I'm very sad, actually, attorney.
Yeah, do you have evidences of that allegations?
Yes, attorney. I have here the evidences that showing. These evidences consist of photos and receipts, actually, attorney, showing the photos and receipts. This attorney.
So a total of?
Total of 79,534 pesos. The receipts showing the materials and the labor that cost me to repair the two apartment units, attorney.
So that is 79,500.
Yes, these are all the
79,534 pesos. Mr.
Yeah.
Habib spent that for repair. Okay, so have you notified the plaintiff?
Yes, attorney. I actually notified the plaintiff that I caused the repair and that it costed me 79,000 plus, and that I have the receipts and the photos. If they would want to see that indeed I this much 79,000 I spent for the repair of the apartment units.
And then they give you another demand letter for the 90,000?
Yes, what happened, attorney, was that they told me that they wouldn't want to have anything to do with the repair of the apartment units, but instead they demanded that I return the 90,000 security deposit without reimbursements.
Oh, that's so
Yes.
sad.
Yes,
So
attorney.
what do you want me to do now?
Yes, attorney. I want you to be my counsel for the case they filed against me before the MTCC of Davao City for collection.
For their case of collection of
sum of money. They
yeah.
filed against me.
Yeah, I can accept that case because we have a good fight there.
Thank you
However,
very much.
Mr. Habib, as you know, we have tariffs that we consider from the Integrated Bar of the Philippines, and some, are you willing to pay the acceptance fee as well as the docket fees for this case?
Yes, attorney. I can afford to pay the acceptance fee for your services, attorney.
Yeah, I want you also to fully participate in this case as well.
Yes, attorney. I will, attorney.
Very well. I will be glad to be your attorney
Okay.
for this case.
So you're accepting me as your client, attorney?
Yes, of course, Mr. Habib. We have a good fight here.
Thank you very much, attorney.
Thank you so much. See you soon.
Okay, attorney. Thank you. My evidence.
Evidences.
Ruling of the MTCC. The MTCC of Davao City found that respondent had the obligation to return the security deposit. The lease agreement does not authorize the outright withholding of the security deposit. The lessor should first bring it to the proper forum to determine whether the lease contracts were violated. Ruling of the RTC. The RTC ruled that the respondent had the right to withhold the deposit until his claim for damages to the units have been reimbursed. Ruling of the CA. The CA ruled that the allegations in petitioner's complaint make out a case for breach of contract and therefore an act for specific performance. As such, it is an action incapable of pecuniary estimation. The MTCC has no jurisdiction over the case since the security deposit is merely incidental to the main action for specific performance. The issue of this case, whether or not the MTCC has jurisdiction over the case. According to the Supreme Court, since the lease had already expired, there is no more contract to breach. The demand for the return of the security deposit was merely a collection suit. As such, the CA erred when it held that the MTCC has no jurisdiction over the case. Moreover, while the respondent must return the security deposit to petitioner, respondent had the right to withhold the same and to apply it to the damages incurred by the apartments units occupied by the petitioner. Therefore, the RTC was correct when it ordered the offsetting of the 90,000 security deposit to the expenses of the repairs amounting to 79,534. Thank you.